Yesterday, I inform you that a hearing was held in which, before the review court, the prosecutors, that is the public prosecutors, challenged the house arrest of Konstantin. Once the hearing took place, in our view, the representatives who intervened yesterday before the review court departed from the issues that constituted the grievance raised by the prosecutors of Dr. Rabora and went beyond them. Issues that had not been subject to adversarial proceedings and had not been addressed were introduced as valid so that, based on the claim that the judge had not properly substantiated his decision, which, in our view, is substantiated, this was one of the grounds on which the decision was revoked, because they allegedly had not clearly identified the topics. Even though the topics arose from the entire adversarial process and due to the urgency imposed by the new procedural code, the decision was fully substantiated and supported by medical records. Because the object of the proceeding was whether Unidad 6 was in a position to provide the necessary elements to safeguard Konstantin's health, and it was not. It was discovered that they could not even translate what Konstantin wrote regarding his state of health. They would bring him a denial, and he would write that he did not understand. And they also failed to comply with the orders issued since April and since September and August, in which the judge ordered Unidad 6 to safeguard Konstantin's health and to provide information on which medications were being administered to him, how he was to be treated, the schedules, and any matter which, in case of doubt, was to be supported by official public translators, whether private or from the state. None of this took place. They distorted the issue and stated that there was no definite diagnosis. This concerns a person who has already lost more than 52 kilograms and where the Sanitaricita hospital validated the studies that had been requested, those that could be carried out and those that could not be carried out, either in that hospital or in the south of Argentina. This led to a broad range of confusion on the basis of which the decision was revoked. And today we inform you that we have filed a request before the same chamber, in General Roca, before the same higher court, the review court, so that other judges may immediately hear this appeal and resolve such arbitrariness. Now, today issues were raised relating to validation, procedural data, and possible nullities. What we've demonstrated today is that we were not granted the opening of this validation. Rather, continuously and uninterruptedly, chats translated by Google Translator have been used to formalize charges and to continue the formalization thereof despite the enormous errors and deficiencies in those translations. What we requested was not that this evidence be excluded. On the contrary, the judge stated, "You will be able to request the exclusion later." What we want, on the basis of equality of arms, is that what is said in Russian be translated by translators, whether from the public prosecutor's office, translators of the court, or party-appointed experts, translated in legal form. This is in order to show that what Google Translator translated is not what is actually being said, and to avoid interpretations whereby translations produced by Google Translator are then translated back into Russian. We've also requested, as a new fact, information regarding the treatment, despite the judge having stated that it had already been addressed, when in fact it had not been addressed, and we have the right for the prosecutors to grant us access to all the information. Information that today they upload, download, remove, and move, and I do not wish to use adjectives, but they handled the incorporation of elements in a non-genuine manner. If there are evidentiary elements that tend to favor or not favor Rudnev, and they have been uploaded, they must remain and cannot be handled in that way. The judge also did not allow the opening of this issue, and as a consequence, we also sought to demonstrate and open evidence that RT is not a victim. That RT, after the Cámara Gesell procedure, hearings and written submissions, and after contact with the minor's public defender, a conclusion has already been formed that she is not a victim. If there is no victim, there is no case, and there is no criminal organization. We sought to change the legal classification, another hearing, and another hearing. This too has already been challenged by this defense, and shortly we will provide you with both rulings for the appropriate purposes. And we believe that for once this case will be put in proper order. Thank you very much.